Okay, have all of the captains returned?
Starburst is here and ready to proceed.
Kit Kat is here and ready to proceed as well.
Okay, so I'll begin with a short introduction and then we can proceed into the trial. So, welcome everyone to the grand finals of the 2025 Dominion Champions Cup. So throughout the 4 rounds of this tournament, we've had some of the best and the brightest competitors from across Canada and the US compete. But the two teams that came out on top is Team Starburst as well as Team KitKat, who prevailed as the most prepared and effective legal advocates. And so today we'll be joined by our very own founder, John Wu, who will be presiding over this trial, as well as Professor Young with the University of Ottawa, who's been researching some of the most pressing issues in Indigenous law. They will then be evaluating students and competitor performance during this trial. So thanks for both judges in joining us today. But I'm sure everyone has been very much looking forward to the finals. So without further ado, we'll get started. Take it away, John.
Hi everyone, hope you are doing well. Yeah, really excited to be here today. I had an opportunity to judge a round earlier, and yeah, it was kind of fun. Saw some really great advocacy, and it's always a pleasure to see young people who are really passionate about the art of trial advocacy. So as Johan mentioned, my name is John. I'm going to be the presiding judge today. Joined by my fellow Justice Frankie Young, who will be the scoring judge. So, throughout this trial, make sure that, yeah, any sort of objections are addressed towards me. Justice Young will strictly be scoring. Um, Now, in terms of the trial, as I understand, there is a pre-trial motion, which is to be determined, specifically with regards to the admissibility of expert testimony by one of the prosecution witnesses. So we're going to start our trial off with that before getting into any sort of pre-trial matters which the teams would like to discuss, and then we'll be jumping right into the trial itself. As I understand, each team is responsible for keeping track of time, their own as well as the other teams. So I would appreciate if each of you could provide regular time checks into the chat here. And if you do have any other questions or points that you want some clarification on, I ask that you just hold off until the pre-trial oral arguments are out of the way. So without any further ado, I think we can get into it. So jumping in, I believe defense is moving in limine to exclude narcotic specialist Jameson Grant's expert testimonies with regards to whether or not being a courier is intentional or unintentional, um, and applying that to today's present case. So, counsel for the defense, are you ready to proceed?
Yes, Your Honor.
Okay. As I understand, each side is given up to 7 minutes to argue their position, with the opportunity to deliver a rebuttal if you would like to reserve some time for that. So, counsel, Ms. Lee, yeah, would you like to reserve any time for rebuttal?
Yes, Your Honor. We'd like to reserve any remaining time to rebuttal.
Okay. Any remaining time to rebuttal? Okay.
Your
Yeah,
Honor,
that sounds
may I
good.
be heard?
Yes. Yeah, Ms. Garcia.
I believe in the briefing that happened earlier about this pretrial oral argument, both sides agreed that there would be no rebuttal.
Okay. Is that correct? Counsel for the defense, was there an agreement made on that?
I believe so. My mistake, Your Honor.
Okay, yeah, no problem at all. Yeah, in that case, I think we can jump in and get started. So, Miss Lee, whenever you're ready, you can begin.
Yes, Your Honor. Good afternoon, Your Honor. My name is Grace Lee, and I stand before you to address a critical issue, an area of the Crown's proposed expert testimony from Grant. More specifically, the section in her report titled Likelihood of an Intentional Courier. The defense submits that this certain testimony fails the well-established test for expert evidence and must be excluded. In R.V. Mohan, the Supreme Court of Canada made clear that expert evidence requires relevance, necessity, the absence of an exclusionary rule, and a properly qualified witness, all of which the Crown must prove. As I'll demonstrate, they fall short on every count. But if you think even one of the criteria is not met by the Crown, you must find in favor of the defense. First, relevance. R.V. Mohan teaches us that evidence must be logically relevant, but can be excluded if its prejudicial effect overshadows its probative worth. A main part of Sergeant Grant's testimony references Parker being financially unstable. She then goes on to say that this makes him likely to have known there were drugs in his truck. The prejudicial value outweighs the probative. Saying he's low on money, so he was a drug dealer, all it does is mislead the jury because it links him to a generic drug trafficker. However, the R.V. Mohan case concluded that a person cannot be judged by a profile that has not been standardized. That's the legal precedent. If this supposed profile that Grant is referencing hasn't even been standardized, then, Your Honor, it's not relevant.
So, like,
It's
what do
solely
you mean by
based-
standardized, counsel? I guess that's what I'm kind of curious about. Like, to what extent does something have to be standardized in order for us to accept that, we can use it in this assessment?
Well, Your Honor, in the case of R.V. Mohan, they tried to link a psychiatrist to regular characteristics of someone who would commit sexual assault, which is what he was being charged for. The characteristics that they referenced in this case weren't standardized because it wasn't something that the expert was 100% like sure about, and this like a profile that hasn't been standardized in their field, and so they weren't allowed to use that testimony.
So I guess like I'm a little bit confused because in that case you said that the inference was this person was a psychologist and that made them more prone to sexual assault, which to me seems like a pretty major jump as far as things goes. There are a lot of psychologists out there, and I would reckon that very few of them would actually end up committing a crime of that nature. Whereas drawing a link between poverty and the need for money, and having that be an incentive to potentially commit crimes like that seems to me to be a much more reasonable sort of jump in logic, right? So,
Well, Your Honor, if I may,
please.
To clarify, the R.V. Mohan case was about a psychiatrist, and they tried to argue that because the psychiatrist didn't fit the characteristics of someone who would normally commit sexual assault, then he should be found not guilty.
Okay. Yeah. So then how would you apply that to this particular case?
Yes, Your Honor. So they tried to say that because a psychiatrist didn't fit the characteristics, they referenced a profile that hadn't been standardized. The characteristics of someone in this profile, because the psychiatrist didn't fit it, then he should be found not guilty. In this case, the sergeant is trying to say that because Jordan Parker, the defendant, fits the characteristics, again, the characteristics of a profile that has been standardized, because Jordan Parker fits the characteristics, then he should be found guilty.
Okay. Yeah. Okay. I see what you're getting at. Yeah.
Your Honor, may I proceed?
Yeah. Go ahead. Yeah.
So there's barely any probative value, barely any relevance. The prejudicial value outweighs the probative. Second, necessity. R.V. Gajul tells us that expert testimony must provide insight beyond the jury's common knowledge, something Grant can't claim. Even if you do believe that Parker's financial situation connects him to the crime, if you believe it's crucial, ask yourself, can the jury figure this out themselves? Well, if it seems like Parker needed money and it seems like a job was being offered to him, the jury can put two and two together. That's what Grant did in her report anyways, because remember, the profile hasn't been standardized. Grant's taking as much of a stab in the dark as you and I. In this particular section of the report, Grant's only using her common knowledge to form the conclusion, not her specialized experience. The jury will have that same common knowledge because the Crown is able to enter the evidence in other ways. But if it's mere generalization in the sergeant's testimony, R.V. Mohan demands more than that. It requires a real gap in understanding that only an expert can fill. The necessity of an expert. But the defendant's financial situation isn't a gap in understanding. He admits it himself. Third, the exclusionary rule. Even if Grant clears the first hurdles, evidence violates other rules. The exclusionary rule in R.V. Mohan states that beyond meeting the 3 other criteria, the evidence must not be barred by other rules of evidence. However, Sergeant Grant is trying to use character evidence, tying Jordan Parker's past to previous involvement with the Cobra Gang and drug trafficking before. That he did it before and he's going to do it again. This evidence, suggesting action and conformity therewith, isn't allowed under Rule 404. Finally,
So if you know you're having an issue with the character evidence claim, I guess one thing I'm curious is why we're discussing this before the trial begins. I mean, isn't it fair to have the opposing counsel at least bring it up during the trial, and then if you want to object, then you can? Why are we excluding this entirely even before the trial begins?
well, yes, Your Honor, it just adds to our argument under the 4 criteria of R.V. Mohan, and that this criteria specifically states that the evidence must not be barred by other rules of evidence. And so it's a part of our argument that this testimony should be excluded.
Sorry, could you clarify like what you mean by that? Maybe I'm not quite understanding. So you're saying under the standard, it can't be barred by any other rule of evidence.
Yes, Your Honor.
Yeah.
The
So
R.V.
explain to me how
Mohan.
that works.
Yeah, so right now, Your Honor, we're trying to show that the Crown isn't meeting the 4 criteria for expert evidence, and this is one of the criteria, the exclusionary rule. And so the exclusionary rule states that the evidence must not be barred by other rules of evidence, but we found a rule of evidence in the insurgency that hasn't been met.
Okay.
Your Honor, did I cut out? Oh,
Yeah,
yes,
just
Your Honor.
briefly, but I think I understood what you're saying. Yeah.
May I proceed?
Go ahead, counsel.
And so, Your Honor, this evidence suggests action and conformity therewith, and under Rule 404 should be excluded. Finally, a properly qualified expert. Here, the Crown's case unravels even with Grant's resume. It's impressive on paper, but R.V. Mohan demands more, specialized knowledge. And Mohan, a psychiatrist's credentials didn't save his novel profiling. R.V. Gajwal also sets the bar. Staff Sergeant Shepard's
Your Honor, but that's time.
Yeah, counsel, I believe time has passed, so if you could, wrap up your submissions. Yeah.
Yes, Your Honor. So, Your Honor, under Stipulation 4, Sergeant Jameson Grant can only testify expert opinions on the narrow topics of distribution, manufacturing, and the sale of cocaine in the region. And so this makes it unreasonable for him to assume a motive of the defendant. So to conclude, as we stated today, this part of the Sergeant Grant's testimony doesn't meet the 4 criteria of expert evidence as stated by the Supreme
Okay,
Court.
thank you, counsel.
To be excluded.
Okay, thank you, counsel. Counsel for the prosecution.
Yes, Your Honor.
Yeah,
May I
whenever
continue?
you're ready.
May it please the court. Good afternoon, Your Honor. My name is Cristiano Garcia, attorney for His Majesty the King. And today, the Crown respectfully requests that Your Honor denies the defense's motion and you allow Sergeant Grant's expert opinion to be admitted because it satisfies all 4 Mohan criteria. Your Honor, for some context of the case at bar, on March 15, 2023, the defendant, Jordan Parker, was stopped for what appeared to be a routine traffic stop. But during the stop, officers discovered nearly 10,000 doses of cocaine in the trunk of his car. And today, The defendant faces a charge of possession of drugs for the purposes of trafficking, contrary to Section 5.2 of the Controlled Drugs and Substances Act. Now, the question isn't whether the drugs were found, but whether the defendant was knowingly trafficking them. And the Crown will present expert testimony from Sergeant Grant, an expert in forensic behavioral analysis within the narcotics field. And her opinion is a simple one. The defendant was an intentional carrier. And as Attorney Lee just said, the admissibility of Sergeant Grant's testimony hinges on satisfying the 4 Mohun criteria for expert evidence. First, relevance. Second, necessity. Third, qualifications. And fourth, absence and exclusionary rule. Let's talk about that first criteria, the relevance. Your Honor, as you know, the bar for relevance is extremely low. And in R.V. Mohun 1994, it said of precedents that any fact that makes a fact more or less likely is admissible. Your Honor, the question isn't whether the defendant knew about the cocaine. Hence, an expert opinion concerning whether someone was an intentional carrier surely is relevant to the matters of today's case. So second, now that we know about the relevance, we'll take a look at the necessity of this expert opinion. Case law R.V. Mohun 1994 set of precedents that expert evidence must assist the jury in understanding matters beyond common knowledge. To determine necessity, we must define what common knowledge means. In a narcotics case, while most people could name drugs like marijuana or cocaine, the specifics of narcotics trafficking behavior goes far beyond this basic understanding. Sergeant Grant's...
So I understand that, the expert that you're calling in is an expert in the space, but what do you make of defense's argument that essentially what your expert is saying is their client is poor, therefore their client is more likely to have committed the crime? Is that your take in terms of what the expert is offering, or is there more that your expert is going to be bringing forward?
Your Honor, that's not exactly what my expert will be bringing forward. In fact, it's the opposite. That was one piece of her puzzle. But instead, she'll also be presenting evidence, such as talking about a specific car the defendant was driving and how that car with different tires and the specific trunk of the car, the Ford D150, is commonly used by intentional drug carriers. Hence, it's more likely the defendant was an intentional drug carrier because she was using that car. Your Honor, it's not simply about the finances, it's about other parts of the evidence that she'll be walking us through.
So, I understand, there's some evidence that's going to be brought forward about the truck, and I don't see any issues in terms of the expert commentating, hey, you know what, this is a truck that's commonly used. I think the point I'm a little bit more concerned about is the expert actually being able to make a conclusion, right, with regards to whether or not this was intentional or unintentional. If they were simply bringing forward evidence that, hey, you know what, this is something that's typically done in the drug trafficking trade, yeah, that's pretty fair. It's not something I know about. I think the jury would find it helpful. But what about the expert's opinion specifically on evaluating whether or not the defendant in this case was trafficking intentionally?
Your Honor, I don't believe the jury would be able to specifically come to that conclusion without expert assistance. Because, Your Honor, with expert assistance, they are able to say, okay, this is the facts, these are the little puzzle pieces, and the expert building them all together helps the jury understand that simply.
So, could you clarify for me, why specifically we need the expert to state, in my conclusion, Jordan Parker is likely to have been doing this intentionally, as opposed to just presenting evidence that the jury can piece together? I guess I'm still having a tough time understanding that.
Yes, Your Honor. We believe that the jury would not be able to just look at the evidence and then conclude whether or not someone was an intentional carrier, because the distinctive character traits is not clear to someone with an average level knowledge. That's why we need expert evidence in this specific instance. And outlined in White, Burgess, Langale, Inman via Hill, Bott & Co., 2015, expert evidence fails to serve gaps in jurors' knowledge, offering a framework for them to make their own conclusions instead of providing definitive answers for them. Now, Your Honor, moving on to my second point, Sergeant Grant's qualifications. Case law R.V. Mohan requires experts to possess specialized knowledge to help the trier fact. Now, Your Honor, unlike Attorney Lee just said, Sergeant Grant is highly qualified as a professional in behavioral forensics within the narcotics investigation. With nearly 2 decades of service, a master's degree in criminal justice, and leadership in the Anti-Narcotics Enforcement Division, her qualifications are undeniable. And they claim that because of a lack of psychological background, that it disqualifies her as an expert. However, if we look at the Supreme Court that they set a precedent in R.B. Bigley 2017, it confirms that practical experience meets the Mohan criteria for expertise. In Bigley, a drug recognition expert, despite no academic credentials, was allowed to testify based on extensive field training. The court emphasized that expert encompasses both formal and hands-on skills. Sergeant Grant's career as an undercover officer has honed her ability to distinguish how intentional killers walk, talk, and act, such as identifying gang-affiliated insignias like the defendant's bumper sticker in the car. In other words, she doesn't have to be a psychologist because her real-world experience satisfies the Mohan criteria for expert evidence. Now, lastly, looking at that absence of an exclusionary rule. Your Honor, Miss Lee
Sorry,
just
I
got
think
up here.
time has elapsed.
Your Honor, may I have 30 seconds of grace period?
Yeah, I'll let you finish up. Yeah.
Yes, Your Honor. She said that there was an exclusionary rule, character evidence 404. However, R.V. Mohan specifically says that evidence will qualify as an exception to the exclusionary rule relating to character evidence, provided the judge, you, is satisfied with the pro's opinion is within the field of expertise of the expert. So
Okay, counsel,
despite
yeah,
there being
I think,
character
yeah, I
evidence.
think that's it. Okay. Okay. I think we're good to go then, since there's no rebuttal period. Okay. So I've heard submissions from both sides. I think I'm ready to make my ruling. For the case of His Majesty the King and Jordan Parker, I'm gonna be denying defense's motion to eliminate in terms of restricting the testimony of the expert. Just based on the submissions, I think, based on the constellation of factors that are present here, and especially evidence that I think is a little bit more niche than I would say what the average person would be able to piece together and to be able to process in an effective way. I think it makes sense in this case to allow the expert to deliver their final opinion based on their analysis of the constellation of the factors. Of course, the jury can disagree with the expert's assessment based on their own final ruling. But I think in this particular case, it would be helpful and it would be necessary in order to provide that extra perspective, especially given the niche nature of a lot of the evidence that's going to be brought forward, which the layperson is unlikely to know how to exactly factor that into their analysis. So, yeah, with that, I think we can wrap up the pretrial motion, and we can proceed into the heart of the trial itself. Thank you to both sides for presenting their submissions. I thought both lawyers did an excellent job. Let's jump in then. Are there any pretrial matters to clarify before we begin the trial itself?
Yes, Your Honor. The Crown has a few preliminary matters, but first, Your Honor, may we make introductions?
Yeah, go ahead.
Yes, Your Honor. Good afternoon, Your Honor. My name is Vivian May, and today I'm joined with my co-counsels, Ms. Cristiana Garcia
Hello, Your Honor.
and Mr. Jason Kuo.
Good afternoon, Your Honor.
And together, we're here with our party representative, Ms. Tom Rodriguez. Your Honor, may we move to a few housekeeping matters?
Yeah, go ahead, counsel.
Yes, Your Honor. First, we'd like to bring the court's attention to some special instructions and stipulations.
Okay, go ahead, counsel.
Yes, Your Honor. First, we'd like to direct the court's attention to stipulation number 6, the authenticity of exhibits, simply stating that all exhibits are what they claim and seem to be, and that no witness and attorney may allege the contrary.
Yeah, so we can skip through the stipulations. You know, if it does end up being relevant in the trial, you can bring it up then.
Yes, Your Honor. May we move to our special instructions?
Sure, go ahead.
Yes, Your Honor. Second, we'd like to bring the court's attention to special instruction number 1, stating that the Crown's party representative will be Tom Rodriguez.
Yes, okay. Yeah.
And finally, we'd like to bring the court's attention to special instruction number 4, extrinsic facts, in which it states that all witnesses may mention any extrinsic facts, but they will also always be subject to impeachment if those facts contradict their obligation with their sworn statements.
Yep, that sounds good, counsel.
Thank you, Your Honor. Tech, we can get the demonstrative down. Moving forward, Your Honor, we just have a few preliminary matters we'd like to discuss.
Yeah.
First, Your Honor, we'd like to ask Your Honor's opinion on striking from the record. In the event that an objection is sustained, would Your Honor prefer us to strike from the record or simply assume that all offending testimony is stricken?
No, please specify exactly what you want stricken from the record.
Yes, Your Honor. So should we motion to strike?
Yes, please, yeah. And
Yes,
be
Your Honor.
specific when motioning to strike. You know, especially if only part of the testimony is objectionable.
Yes, Your Honor. And second, we'd like to ask Your Honor's preferences on screen sharing. Should we ask for permission to screen share or simply state for the record?
No, you can just do it, counsel. Just give me a heads up that you know, you're gonna be tossing up a screen share.
Yes,
And
Your Honor.
yeah, you can put it up whenever you want.
Yes, Your Honor. And finally, we'd like to invoke Rules 603 and 615, constructively swearing in and sequestering all witnesses, barring the party representatives.
Yes, that'll be done.
Yes, Your Honor. And with that, the Crown is ready to proceed to opening statements.
Okay. Excellent. Then, counsel for the defense, any preliminary matters that you'd like to run by the court?
Yes, we do have some things to say before the trial starts. May I
Yeah, go
proceed?
ahead, counsel.
My name is Matthew Shen, and today I'm joined by my co-counsel, Ms. Grace Lee,
Good afternoon, Your Honor.
and Mr. Jaden Hong.
Good morning, Your Honor.
Together, we represent the defendant in today's case, Mr. Jordan Parker. We would also like to designate Mr. Jordan Parker as our party representative and note that he will be joining us throughout the trial. And with that, the defense is ready to proceed.
Okay, sorry, give me one moment. I'm just getting my notes ready. Okay, I think, yeah, we can jump in and get started. Counsel for the Crown,
Yes, Your
Ms.
Honor.
May, yeah, please begin your opening statement whenever you're ready.
Yes, Your Honor. May it please the court. He concealed for cash. The defendant, Jordan Parker, is gripping the steering wheel. His palms are sweating as he nervously checks his rearview mirror. He's desperate because there is a package of cocaine in his trunk. That's illegal. And just as he thinks he's going to get away with it, he's pulled over and caught. And so now the question we have is why? Why would the defendant be so desperate that he would smuggle drugs? Money. You'll learn today that Mr. Parker was drowning in debt. He needed a way to make some quick cash, and there's a lot of money involved when it comes to smuggling drugs. So he concealed for cash. And so today, the Crown has charged the defendant, Mr. Jordan Parker, with possession for the purpose of trafficking, and thus will prove beyond every reasonable doubt that the defendant willingly took that cocaine to be distributed. We understand that while that's a high burden, it's not impossible to meet. And in fact, we'll meet it today with two simple facts: the concealing and the cash. First, he concealed the cocaine. And today, the arresting officer of the defendant will take that stand and tell you that she found the defendant with a block of cocaine in his car. And she'll reveal the defendant knew what the package of cocaine was before even seeing it. An expert on narcotics will reveal that this block was made of nearly 10,000 doses of cocaine. Both officers will tell you that there was a symbol found on the back of the defendant's car. But that wasn't just any symbol. That was the mark of the Cobras, a gang notorious for drug trafficking. And so second, the cash. You'll hear from the defendant himself today that he wasn't doing well financially. He just lost his job in the pandemic, and this new one wasn't doing much to help his financial state. The defense's own witness will take that stand and tell you that the defendant was spotted talking to members of the Cobra gang just days before the crime occurred. He concealed for cash. Now the defense, today they'll ask you to look at how there's no forensic evidence and no physical evidence. But we don't need any of that, because we'll show you how the same symbol on the cocaine was found on the back of the defendant's car, and how the defendant had previously interacted with the same gang to smuggle drugs. And that's why, at the end of today's trial, my co-counsel, Mr. Jason Kuo, will stand before you and ask you to reach the only just verdict. He concealed for cash. Find him guilty.
Thank you, counsel. Just want to give my fellow justice scoring. Okay, I think we can jump in and get started then. Counsel for the defense, Mr. Shen, whenever you're ready to proceed.
Thank you. May it please the court. Caught without a clue. It's the morning of March 15, 2023. At 11:30 a.m., Jordan Parker was driving home, alone after visiting his family. It was a normal drive until he was pulled over in what should have been a traffic routine stop, which turned into something far more serious within hours, because Jordan was accused of possession for the purpose of trafficking, a crime he did not commit. The prosecution will present a case that suggests that Jordan knowingly transported illegal drugs. But the evidence you will hear throughout this trial raises important questions. Questions about the vehicle. Questions about the investigation. Questions about the reliability of the accusations made against him. Now let's start with the vehicle. You will hear that Jordan was driving a rental truck, Door D150, It was not his personal vehicle, but it had been used by multiple people before him. The drugs in operation were found in a hidden spare tire, a location not easily accessed or checked by someone simply renting the vehicle. As you listen to the evidence, please consider this. If Jordan had truly intended to transport drugs, why would he use a vehicle recently used by others? A vehicle that could have been inspected or searched any time. You hear from an officer who made the stop, pulled over Jordan for the tinted windows, not for any suspicion of drug activity. Yet that stop escalated quickly. A police dog barking alerted the back of the truck, leading to a search. However, you won't hear is the body cam footage, because it doesn't exist. The officer, despite the prima facie, has failed to turn on his body camera. The prosecution also may suggest that Jordan has ties to the Cobra Gang, a group known for criminal activity in all Dominicana. But simply knowing or being seen with certain individuals does not make someone guilty of their crimes. In a neighborhood where gangs are widespread, avoiding all contact with their members is nearly impossible. The evidence in this case will not show any link between Jordan and drug operations because there is no such links. The prosecution will also argue that Jordan reacted suspiciously when the drugs were discovered. But the evidence will show that the drugs were hidden in a location Jordan could not see, inside the spare tire. The back of the trunk. Despite this, the officer claims reacted before he even saw what was found, considered what is more likely that Jordan somehow knew about something he couldn't see. Or simply, he was confused and shocked by an accusation he never expected. At the end of this trial, the prosecution will show that the doubt is not just present, it is overwhelming. As you listen to the witness testimony and the facts, I ask you to keep this in mind. Suspicion is not proof. Assumptions are not facts. And in our justice system, doubt means you must presume innocence. We plead a verdict of Jordan Parker not guilty. Thank you.
Sorry about that. Let me get my phone silenced here. Calls coming in. Thank you, counsel. All right. I think we can move into the case in chief now. Counsel for the Crown, are you ready to call your first witness?
Yes, Your Honor. We'd like to call Ms. Tom Rodriguez to the stand. Your Honor, may I proceed?
Yeah, go ahead, counsel.
Yes, Your Honor. Good afternoon, ma'am. Can you please introduce yourself to the court?
Good afternoon. I'm Tom Rodriguez. People call me Tom for short. My parents thought I'd be a boy, but no, I came out as a girl.
Well, officer, what do you do for a living?
I'm a patrol officer at the New Dominicana Police Service, where we have the best donuts served with a side of justice.
Well, how'd you get that job?
Well, I was the youngest appointed patrol officer at the New Dominicana Police Service.
So how are you involved in today's case?
I pulled over and arrested defendant Jordan Parker on March 15th, 2023.
And why did you arrest Ms. Parker?
Well, I found a package that was late tested to be cocaine in their car.
All right, ma'am. Your Honor, at this time, we asked the defendant to turn on their camera for identification purposes.
Yeah, go ahead, counsel.
Ma'am, can you identify the defendant based on an article of clothing?
Yes, they're wearing a white shirt and a tie.
Let the record reflect that Officer Tom Rodriguez has identified the defendant. So, ma'am, let's talk about what you found the defendant when you found the defendant concealing cocaine. What were you doing on March 15th?
Yeah, I was patrolling the I-102, just munching on my daily donut from the station, drinking my coffee and listening to Taylor Swift on the radio.
So, ma'am, what happened after that?
All of a sudden, a car passes with overly tinted windows, and it's against the rules, so my drive for justice kicked in and I pulled them over.
Was that process recorded?
Unfortunately, no. I was during the heat of the moment and I completely forgot to turn on my body camera. However, I have a drawing of the scene that I made right after the incident.
Well, then, officer, let's set the scene. Your Honor, let the record reflect that we're about to screen share what has been marked as Exhibit 5, as well as a demonstrative. Officer, what I just displayed on screen here, what is this?
This is the drawing I made after the incident to document everything.
Does it seem to be fair and accurate?
Yes.
The Crown offers Exhibit 5 into evidence.
Okay, any objections?
Yeah, in terms of lack of foundation.
Okay, explain, counsel. And for future
So we
reference,
put it-
please, please try to, give a little bit of additional context, right?
Yeah, of course. So my response is, before the truck can be admitted, the prosecution must prove it is the same vehicle allegedly used in the crime, and that Parker has control over it at a relevant time.
Okay, any response from that?
Yes, Your Honor. Officer Tom Rodriguez right here has just laid the foundation that this was the drawing that she made right after she pulled the defendant over. Thus, as labeled here, this is the defendant's car as Miss Rodriguez saw it and as she drew it.
Okay, so counsel for the defense, what else? What else does the Crown need to do in terms of laying foundation here?
I mean, if there are gaps in the chain of custody or rental records, this objection can exclude it.
I mean, I think the witness has laid sufficient foundation as far as them being the one to put it together. At this point, I don't think we're going to be spending too much time on the chain of custody issue. So we'll allow the Exhibit 5 to be entered. Yeah, go ahead, counsel. You can continue.
Yes, Your Honor. So based on this drawing, when you pulled the defendant over, where was she standing?
Well, this red circle here represents where the defendant was. This blue circle is where I was, and this green circle is where my K9 buddy was when he started to bark.
Well, why did Buddy start to bark?
Well, I took a look and I found a package of what was later confirmed to be cocaine after I sent it to the police labs for testing. I noted there was a specific symbol on the package, like a hashtag.
Well, officer, where did you find that cocaine?
In the tire in the trunk of the car where I have circled in red.
All right, then, so would you recognize a picture of that package if I showed it to you today?
I would.
Let the record reflect that we're about to display what has been marked as Exhibit 9. Ma'am, what is this?
This is the picture of the package.
Does it seem to be fair and accurate?
Yes.
The Crown offers Exhibit 9 into evidence.
Yeah, any objections?
There will be no objection to this exhibit.
Okay, Exhibit 9 is entered.
Yes, Your Honor. All right, officer. So let's see if that defendant could have been concealing for cash. Did anything happen when you found that package?
Yeah, as soon as I saw the package, I saw a symbol on it, and before I had entirely even pulled it out, I heard the defendant yell something like, "I don't know how that got there. Honestly, you've got to believe me." I don't know why they would say that because I hadn't even shown them what I found yet.
Well, did you find anything else?
There was a symbol on the package, and I also found the same symbol on the back of the car as well. I documented that here too.
All right then. So would you recognize a picture of that symbol on the back of the defendant's car if I showed it to you today?
Yes.
Your Honor, let the record reflect that we're about to screen share what's been marked as Exhibit 3A.
Okay, go ahead, counsel.
Ma'am, what is this?
I'm so sorry. I believe I cut out.
No worries, ma'am. What is this?
Wi-Fi's not the best. This is the picture of the symbol I found at the back of the truck.
Fair and accurate?
Yes.
The Crown offers Exhibit 3A into evidence.
Yeah, any objections?
Objection as to hearsay.
Your Honor, if I may?
Explain, counsel. Why is this hearsay?
If this photograph was not taken by Officer Rodriguez or it lacks personal knowledge of its accuracy, it is an out-of-court statement being offered matter asserted.
I'm not too sure if a picture counts as a statement here, so do you have any other grounds that you're objecting it to outside of hearsay?
As to relevance also.
Okay, explain why this is not relevant.
I mean, there's no clear link between this truck and my client beyond more possession without proof connecting the truck directly to the alleged crime. This photo has little probative value and serves only the mislead of the jury.
Yeah, okay, I'm gonna overrule the objection. Yeah, Exhibit 3A is entered.
Yes, Your Honor. May I proceed?
Yeah, go ahead, counsel.
All right, ma'am. So do you know what that symbol is that you found?
No, all I can say is that I found it on the back of the defendant's car.
All right. So based on all of this, what can you tell us?
Well, I pulled Miss Parker over on the I-102, and I found a package of cocaine with a symbol on it in the spare tire. I found the same symbol on the back of the defendant's truck too.
Thank you for your time today, ma'am. Your Honor, at this point, I have no further questions.
Okay, thank you, counsel. Okay. All right, counsel for the defense, cross-examination.
Yeah. May I proceed?
Yeah, whenever you're ready, counsel.
Now, Officer Rodriguez, you have worked in the law enforcement for 5 years, correct?
Yes, and I also was the youngest appointed officer.
And you were previously stationed on P10 due to department policy issues. Isn't that right?
Yes.
And you have received internal reprimands for violating department policy, correct?
Well, yes, I have, but as I said, I was pretty young back then when I joined the police station, and honestly, it's about the mistakes we make along the way that really helped me become the police officer I am today. And I'm really, really sad that I made those mistakes before, but it helped me become better.
Of course, but please answer my questions with a yes or a no. I'm going to repeat my question again, as I haven't received an actual answer. You have received internal reprimands for violating department policy, correct?
Well, yes, I have.
And you would agree that the past disciplinary actions would affect how people perceive your credibility.
Well, yes, but like I've said, I was pretty young back then, as I did join the police force at a young age, but I think so.
on that day you stopped Parker, were you actively looking for drug-related offenses?
Well, I wasn't actively looking for drug-related offenses. I stopped Parker because of their tinted windows.
Again, please just say yes or no for time. And continuing on, you pulled over Parker because of the tinted windows, correct?
Yes.
And did you confirm whether the tint level violated legal limits?
Oh, yes, I did. And then I told them that they needed to pay a fine.
And did you check the rental agreement to see if the tint was present before Parker rented the vehicle?
Could you repeat the question? Sorry.
Did you check the rental agreements to see if the tint was present before Parker rented the vehicle?
Objection, Your Honor, as the lack of foundation, may I be heard?
Yeah, go ahead, counsel.
We've not yet heard anything on the record as to rental agreements or tinted windows. We don't even know if records of tinted windows would even be on a rental agreement. Thus, opposing counsel asking this line of questioning would be considered lack of foundation.
Okay, any response,
respond?
counsel?
If the tint was pre-existing, it undermines the reasonable suspicion, making the stop potentially unlawful.
So yeah, like I mean, what do you say to the lack of foundation? Do you feel like adequate foundation has been laid?
Yes.
Okay, could you give me a reason why?
Well, I've already asked her about the questions about the tint, as I said, like, because she pulled over for the tinted windows. So I'm just asking her to confirm if the tint level was violated by the legal limits.
I think opposing counsel was more addressing the issue specifically as it pertains to the rental agreement. So yeah, I'll sustain the objection, counsel. If you want to like just lay a bit of foundation, because thus far we haven't really talked much about a rental agreement. If you want to lay some more foundation on that, that would be great.
Yes, Your Honor, motion to strike all mentions of the rental agreement.
Yeah, we can do that.
Yes, Your Honor.
May I proceed?
Yeah, go ahead, counsel.
And before Parker rolled down his window, you saw movement inside the vehicle, correct?
Well, yes, Parker was in the vehicle.
And could that movement have been Parker retrieving his license and registration?
Well, yes, it could have been.
And when Parker rolled down his window halfway, did he refuse to follow your instructions?
No.
And your police dog later alerted the rear of the vehicle, correct?
Yes, my canine started barking at the back.
And at that moment, Parker was standing near the front of the truck, wasn't he?
Yes.
And you would agree that Parker could not see the back of the truck from where he was detained.
No, I think not.
Okay. And you claimed that Parker said, "I don't know how that got there," and you had physically shown him what you found at that point.
No, I hadn't. I barely pulled it out, and then Parker said, "I don't know how that got hit there. You've all got to believe me, officer."
And is it possible Parker was reacting to your body language or assumptions rather than the knowledge of known drugs?
Objection,
Well-
Your Honor, calls for speculation.
Yeah, sustained. Please reword the question, counsel.
Is it possible that Parker was reacting to more of your movements of your body language, or like rather than knowing what was actually behind the trunk?
Your Honor, at this time I re-raise.
Yeah, counsel, could you reframe that question one more time?
Is it possible that Parker was reacting to
Yeah, counsel, I'm gonna have to ask you to move on at this point.
and did you wear gloves when handling the package of drugs?
Well, yes, of course. It's standardized procedure to not touch evidence without gloves.
And were any fingerprints lifted from the package to confirm Parker ever touched it?
That's not my line of work, sir.
But did you check the rental history to see if previous renters had access to the vehicle before Parker?
Objection, Your Honor. Once again, as to lack of foundation, as you previously ruled, all mentions of the rental have been stricken from the record. Thus, opposing counsel asking this line of questioning on the rental does lack of foundation.
May I respond?
Sir, could you repeat that again?
Yes, Your Honor. As you previously ruled, the mentions of any rental activity for this car have been stricken from the record, and thus opposing counsel currently asking the witness about if the tinted windows or anything was on the car in the rental agreement is a lack of foundation.
Okay. Yeah, counsel, could you lay some foundation just for that rental agreement?
May you repeat your question again?
Yeah, counsel, could you just lay some foundation for the rental agreement?
Yeah. So before you checked Parker's vehicle, has there any been previous renters that had access to the vehicle before Parker?
Well, I don't know if any other renters had any previous rentals of that car with the tinted windows, but I do know that Jordan Parker was in possession of the car at the time, so that's why I had to fine Parker for the overly tinted windows.
And moving on, your body camera was off during the entire stop, correct?
Well, yes, in the spur of the moment, I forgot to turn it on, and I just had to pull them over really quickly.
And again, please answer with a yes or a no. You could have a redirect later. And moving on, failing to activate your body camera is a direct violation of the department policy, isn't it?
Well, yes, but it's not a mistake I'm proud of. It's a little embarrassing actually for me. But before that, I've always turned on my camera, and like I said, it was just in the spur of a moment.
Again, just please answer with a yes or a no. Moving on, without camera footage, is it fair to say this case relies entirely on your testimony?
Could you repeat the question? Sorry.
Without any camera footage, is it fair to say that this case relies entirely on your testimony?
Well, yes, but sir, as a police officer, I wouldn't lie.
But other than the single bag of cocaine, did you find any other illegal substances in the vehicle?
No, just a bag of cocaine in the tire.
Thank you. No further questions, Your
Honor. Your Honor, seeing as our jurisdiction doesn't have a redirect examination, may Mr. Rodriguez be excused?
Yeah, Mr. Rodriguez can be excused. I think we're gonna jump right in then. Counsel for the Crown, call your next witness.
The Crown calls Jameson Grant to the stand, Your Honor.
Okay.
May I proceed?
Yeah, go ahead, counsel.
Thank you. Good afternoon. Could you please introduce yourself to the members of the jury?
Good afternoon. Yes, my name is Jameson Grant.
What do you do for a living?
Well, by day, I'm a sergeant and narcotics specialist for the Royal Dominicana Mounted Police. I currently lead the organization's anti-narcotics enforcement division, but by night, I trade my lab coat and start my second job, being a mother for 2 toddlers.
What qualifies you for this role?
I spent 23 years as a law enforcement officer, mostly focusing on manufacturing and distribution of cocaine. You can see my certifications of completion over here. I often investigated as an undercover operative, kind of like the spy movies where I conducted live sweeps of illegal drug manufacturing operations. And of course, I tracked known drug traffickers.
What do you do in your current line of work?
I continue to work on stopping the spread of narcotics, and I've trained over 500 recruits in general law enforcement and special narcotics training.
How are you involved in today's case?
I was assigned this investigation after the discovery of illicit substances in the defendant, Mr. Parker's truck, and later I formed a conclusion based off my personal expertise.
What materials did you rely on to form your conclusion?
I'm familiar with the affidavits of Jordan Parker and Leslie Blake, and the sworn statement of Officer Tom Rodriguez. I also used exhibits 1 through 9 in my investigations. Specifically, I was able to test the cocaine from exhibit 9. I was also able to interact with Jordan Parker's vehicle.
In making your conclusion, did you use any methods?
Yes, I used a dual narcotics investigation procedure and a method of my own. Of course, all reliable. I call it the Triple C method, and it helped me put all the little puzzle pieces together and look at the bigger picture.
Have you testified in court today before this incident?
Yes, 29 cases actually, all directly related to cocaine distribution. At this point, I should probably have my own parking spot at the courthouse.
In this case, do you know where the defendant was found with cocaine?
Yes, I-102 highway. It's a very common trafficking route.
Screen sharing a demonstrative the witness has made, constructively hiding the left half of it from the witness's view.
Okay, go ahead, counsel. From the witness's view?
Yeah, the left half from the witness's view.
Okay.
Co-counsel, if we can get the...
Just before you get this in, just to confirm, opposing counsel has had the opportunity to review this?
I'm not sure, I wasn't there in captain's meeting. If co-counsel can clarify?
Counsel for the defense, have you had the chance to review this?
I'd have to ask my captain for that. Let me ask.
Your Honor, my co-counsel just clarified, and they said the defense didn't in fact see this.
Okay. Yeah, can defense counsel confirm that?
Just 1 second, Your Honor. We are having some communication issues. Yes, they have shared this demonstrative with us.
Okay.
Yeah, sorry,
Yeah,
Your Honor, just to...
Yeah, please go on.
Yeah, sorry, just a clarification. We'll be screen sharing the entire exhibit and will not be constructively hiding any part, so the witness can see all of it.
Okay. Yeah. Yeah, that's fine.
Let's begin with the method you mentioned just a moment ago. Can you explain what it is?
Yes, it's the Triple C method, which stands for cocaine, couriers, and cash.
Beginning with the first C, the cocaine, what did you discover about it?
I was able to test the cocaine in that picture, and I discovered it was discovered hidden in the defendant's car. After testing it, it was around to be 470 grams. Now that is much more than a normal dose for individual use.
So how much is normal?
Around 30 to 70 milligrams. So roughly 50 milligrams if we meet in the middle. And if we were to do the math, yes, I did use a calculator for this one, Mr. Parker had roughly 9,400 times the normal dose.
If it isn't for normal use, what would the cocaine be used for?
It's likely the cocaine was used for distribution purposes. Now, while there's no real standard about how much cocaine it takes to be considered distribution quality, the amount of cocaine in the package the defendant has was enough for them to be considered a drug courier. That brings me to the second part of my Triple C method, courier.
What's a drug courier?
Drug couriers, also referred to as drug mules, are people who transport drugs and smuggle them illegally. They're often used by gangs and for some form of financial compensation.
Are there big gangs in Old Dominicana?
Yes. The most influential gang in the area are called the Cobras. The symbol you see there on screen, that little H or hashtag, is the symbol for the Cobras.
Is there any way to tell if someone is a drug mule for the Cobras?
There are signs, of course. In this case, I saw that Cobra symbol on the package that contained the cocaine and a sticker of that exact same symbol on the back of Mr. Parker's truck.
Why would people smuggle drugs for gangs?
Most likely it's for money. That brings me to the last part of my triple C method, cash. People who are struggling financially tend to be more susceptible to gang influence. It's a simple job to smuggle cocaine, and if they succeed, they'll get paid.
Do you know if the defendant had those financial problems?
I do, actually. I know she was poor and struggling financially.
How do you know?
The defendant actually said it himself in an interview.
Did your analysis of Deputy Rodriguez's affidavit add to your conclusion?
Yes, it really jumped out at me, especially her arrest of the defendant. Because what stood out to me the most was the defendant said the package of cocaine Deputy Rodriguez found wasn't hers before she even got a look at the package or its contents.
So how did you put all of these facts together?
Well, I'd like to use a little analogy. Let's think about a puzzle. So, yes, I did bring a puzzle for court today, and yes, it is my son's, but in a puzzle, you're looking at the big picture. This is the end result that we're trying to look at, when the pieces all finally come together. Now, over here, well, this is just a little snippet of it. And as you can see, the strange symbol on the back, well, that was just one piece of the puzzle. We can slot it in over here. The strange interaction with Deputy Rodriguez. Well, that's just another piece of the puzzle. The symbol on the truck of the defendant's car, that's another piece of the puzzle I had. And finally, the defendant's financial situation was another piece that I was able to slot in. And in the end, we have a completed puzzle, and I'm able to make my conclusion.
So, Ms. Grant, what is your final conclusion today on whether the defendant was or was not caught without a clue?
So, based on all of my expertise and my investigation, I can confidently conclude that Mr. Parker knowingly smuggled cocaine, making him an intentional drug courier.
Thank you, Sergeant Grant. Nothing further, Your Honor.
Thank you, counsel. Okay, cross-examination.
Yes, Your Honor. Permission to proceed?
Yeah, whenever you're ready, counsel.
Good morning, afternoon, or wherever in the world you are, Sergeant.
Good afternoon.
So let's dive in. You started this investigation on May of 2023, correct?
Yes, that's right.
And you were paid $500 per hour on any research and preparations you did, correct?
Yes, very standard compensation for experts.
On top of that, you're paid $750 per hour on any testimony you deliver, correct?
Yes, for compensation of my time.
And you agree that this is on the higher end of the industry standard, right?
It is slightly on the higher end, but if we take into account my decades of experience, it really is an accurate reflection.
Of course. Furthermore, you've testified in over 29 cases, correct?
That's right.
And every single one you've testified for the Crown, right?
Yes, I've testified for the Crown in the past.
All right. Let's go through your conclusions one by one. You claim my clients had the traits of an intentional drug courier, right?
Yes, I had all the pieces, from the financial instability to the Cobra symbol found on the truck. It all added up.
But even if those things added up, it's not a guarantee that that person is an intentional courier, correct?
Well, based off my investigation, that is the conclusion I have reached today.
Let me restate my question. Even if they match certain components of the profiling, that isn't definitive proof that that person is an intentional courier, right?
Well, of course, there's no 100% guarantee, but looking from a scientific perspective, based off the evidence I was provided and the evidence I got on my investigation, I can conclude using my expertise. It was intentional.
But you can't guarantee 100% based on this profiling alone, correct?
I guess I can't do 100%, but I can be really sure.
Of course. You claim that the 470 grams of cocaine found is a sufficient distribution size, correct?
Yes, it's much more than normal dose, so it'd be reasonable to assume.
However, it is an unusually small distribution size. You would say that, right?
Yeah, it's on the smaller end.
It's also only a single package.
Yeah, it was a package, but it did contain almost 10,000 times for a normal dose.
If you could answer my questions with a simple yes or no, that'd be amazing. For the sake of the jury's time, of course. It was only a single package, correct?
Yes, I found one package.
Thank you. And additionally, you concluded that Mr. Parker's usage of the I-102, a common drug highway, made it likely he was aware of distribution schemes, correct?
Yeah, that was also just another piece. I-102 is very commonly used for drug trafficking.
But the I-102 is also used by law-abiding innocent civilians as well, correct?
Of course.
And along with that, the Door D-150 in Mr. Parker's possession had modifications utilized in drug transportations. You'd agree with that, right?
I'm sorry, I didn't understand the question.
Of course. The Door D-150 in Mr. Parker's possession had modifications utilized in drug transportation, correct?
Are you referring to his car?
Yes, the Door D-150, his truck.
Yeah, the truck did have a tire, which is where the cocaine was stored.
But you are aware that this was a rented truck, correct?
Yes, I'm aware it's a rental.
Objection relevance, if I may explain.
Okay, go ahead, counsel.
I understand relevance is a low bar, but in this case, the fact that the car was rented makes it no more likely or no more less likely that the defendant was an intentional carrier. They're entirely possible of intentionally carrying drugs on a rental car, not unintentionally carrying it on a rental car, intentionally carrying it on a non-rental car, etc. There's no indication what the relevance for this is.
Okay. Yeah. Any response, counsel?
Your Honor, the Crown has claimed that the modifications made on the truck made it more likely that the defendant was an intentional drug courier. However, if it was a rented truck, he would have no control over the modifications made on the truck. Therefore, we are trying to establish that.
Okay,
Your Honor,
overruled.
Yes, Your Honor.
All right, let me re-ask the question. You are aware that it was a rented truck, correct?
Yes, I am.
Meaning he would have no control over the modifications on the truck?
Yes, while it's possible the Cobra symbol was already on the truck, it's an equal possibility that the defendant put the sticker on the truck himself.
Yes, but not only the sticker, the tinted windows, and the spare tire, he would have also had no control over that, correct?
No, but he could have made those modifications himself.
Right. And you found a Cobra symbol among Mr. Parker's belongings, correct?
That's right, on the truck.
But beyond that, there's no proof of connections to the Cobra, correct?
Well, there was the sticker on the package that was found. There's the same Cobra symbol on the truck. There was a lot of connections.
Let me restate my question. But beyond the Cobra symbols found in his belongings, there's no proof of connections to the Cobras beyond that, correct?
Beyond the stickers, there wouldn't be anything.
No DNA?
There were no DNA.
No fingerprints on the package or on the sticker?
No, we didn't find the Cobra's fingerprints on the sticker.
No recorded or written communications?
We didn't find any of those.
All right, thank you for your time. No further questions, Your Honor.
Thank you, counsel. Okay, I think that that wraps up the case in chief for the Crown. I think at this point we're making pretty good time, all things considered. So let's take a quick break. We're a little over an hour as far as timing goes. So let's take a quick break. Everyone go get some water in you, stay hydrated. use the restroom if you need to. We'll regroup at 1:30 and we'll continue with the defense case in chief. All right?
That sounds great, Your Honor.
Okay, everybody. I think we're good to jump back into it. Counsel for the Crown, are we present?
Yes, Your Honor. The Crown is present and ready to proceed.
Okay, and counsel for the defense?
The defense is also ready to proceed.
Okay. Thank you, Mr. Shen. Are you going to be calling the next witness?
Yes, we'll be calling up Leslie Blake.
Okay. Yep.
Good afternoon, everyone.
May I proceed?
Yep. Whenever you're ready, counsel.
Good afternoon, Miss Blake. Will you please introduce yourself to the court?
Oh, of course, darling. My name is Leslie Blake. I'm 62 years young, and I live all on my own. No partner, no kids, just me and my 20 cats against the whole wide world.
And Miss Blake, what do you do for a living?
I'm retired now, but I did serve in the military.
Thank you, sir, for your service, ma'am. But where do you live?
I've been in Old Dominicana my whole life, right next door to the Parker family. I basically watched them grow up.
Now, you mentioned the Parkers. Do you know the defendant?
Oh, I adore that boy. I've known him since he was in diapers, and let me tell you, he was the sweetest little boy. He's always helping me carry groceries. He's always saying, yes, ma'am, or no, ma'am. He's such a kind soul.
Objection, Your Honor, as to character evidence.
Okay. Could you explain, counsel?
Yes, Your Honor. The witness on stand here is currently offering character evidence for another witness in trial. They're offering evidence of how Miss Park, or rather Mr. Parker, was polite and nice to the witness right here, and that's character evidence.
Okay. Any response from the defense?
I mean, this just establishes her proximity to her crime scene and opportunity to observe the events that unfolded on the night in question.
So, I mean, like, there's nothing wrong with character evidence as long as it's defense offering it in a criminal case. If it were the Crown doing it, I think that would be a bit of an issue. But I think positive character evidence here is allowable under the mercy rule. Of course, counsel for the Crown can try to rebut this on cross-examination. But I guess, this might be a question for you, counsel for defense, Mr. Shen. Have you given prior notice that you intend on offering character evidence to the Crown?
I'm sorry.
Have you provided notice that you intended on offering character evidence for your client?
No.
Okay. I mean, if that's the case, yeah, I'm inclined to sustain the objection just because Miss May really wouldn't have had much of an opportunity to prepare for that. So we'll get the testimony stricken from the record. Counsel, if you want to ask a different question, that's fine. Yeah.
Okay.
Yes, Your Honor.
Yeah, and Miss Blakes, if you could just refrain from speaking to the defendant's character in your responses, that would be great.
Of course.
May I proceed?
Yeah, please go ahead, counsel.
You also mentioned oh, sorry about that. Do you know if the defendant has ever been affiliated with the gang called the Cobras?
Oh, heavens no. I mean, I know that child. I don't think he's ever gonna do anything like that.
And have gangs been an issue around Old Dominicana?
Oh, for sure. I mean, you hear all kinds of ruckus at night, folks up to absolute no good, but I still do my part and remind everyone that Miss Blake is always going to be watching.
And you also mentioned some unexpected ruckus that night. How often do you get woken up?
Well, ever since the military, I've had some trouble sleeping. My brain just don't know how to shut off at night, so I would say pretty often, actually.
I'm so sorry to hear that, man. But I'd like to direct your attention to the case. Did you see what Parker was doing on the day of March 9th, 2023?
I did see Jordan pull in from the driveway, and I went to have a little charm and talk with him, like any good neighbor would. And he told me something about coming back from New Dominicana to visit some family.
And what else do you remember from the conversation?
Well, bless his heart, he did tell me his car went and gave up on him the way here, so he had to rent a new truck. It looked a little chopped, I say, but hey, times are tough since the pandemic. Ain't nobody's wallet looking too plump these days.
And I would like to direct your attention to the night of March 14th, 2023. Were you home that night?
Oh, of course, darling. I was watching Family Feud. Best part of my evening, and let me tell ya, if they ever let me on that show, I win it all. Ain't nobody quicker on that buzzer than me.
And did you see anything unusual happen that night?
Oh, yes, I was just drifting off when I heard a loud crash. Sound like something got knocked over real bad. Now, I may be old, but my ears are sharper than a darn hound dog on a porch.
And did you hear anything?
Well, it was real dark. Streetlights been out for months, bless them, but I could see a shadowy figure near the Parkers' driveway.
And did you recognize any voices or hear any voices?
I did, but no one I recognized. I really thought it might be Jordan, but I know Jordan's voice like I know my own cookie recipes, and his voice was not one of the ones I heard.
And you told us that you didn't hear Mr. Parker's voice. Could you identify anyone else there?
Ugh, it was too dark to see anyone. I really wish they fixed the streetlights, but I know what I didn't hear, and I didn't hear that boy Jordan for sure.
And did you do anything to help Mr. Parker? Yeah.
Of course I did. I don't want that boy Jordan in trouble, so I did what any respectable lady would do, and I hollered something fierce. Then they skedaddled away real quick.
Well, and what did you do after that?
Well, sometimes when your lady wakes up, she doesn't really remember what happened, so I usually drop it down in my journal.
Would you recognize a copy of your journal if I were to show it to you at court today?
I probably would, by God.
Your Honor, let the record reflect that I'm going to screen share what has been previously marked as Exhibit A through C.
Okay. Go ahead, counsel.
If under counsel could screen share. I think we are having technical difficulties as of now.
The Crown can screen share if you would like.
Yeah, that would be great.
Okay, there we go. Yeah, I think it's working now.
And moving on, does this appear to be a fair and accurate copy?
Oh, absolutely. This I remember plain as day.
And Miss Blake, just making sure this is your journal, correct?
Let me take a looky. Hold on, it's a little hard to see if it's sideways, but that sure is my journal. Nothing but the truth in there.
Your Honor, defense moves to enter Exhibit A to C into evidence.
Okay. Any objections, counsel?
Yes, Your Honor, as to hearsay. May I explain?
Go ahead, counsel.
Yes, Your Honor. Miss Blake's journal right here is an out-of-court statement that's being used for the truth of the matter asserted because Miss Blake is writing down what she thinks happened.
May I respond?
Okay, go ahead, counsel.
Honor, we move to admit Exhibit 10AC into evidence under the rule of 8031, the present sense impression exception to the hearsay rule.
Okay, so you're saying this is a present sense impression?
Yes.
Okay, any response?
Yes, Your Honor. We haven't yet heard that this record was made in a timely manner at or near the time of which Miss Blake right here perceived these events. In order for this to be considered 8031, it has to be made at or near the time. We have to hear that foundation.
May I respond?
Okay. Yeah, go ahead, counsel.
This journal entry was made by Miss Blake at or near the time of the events in question, documenting her immediate observations.
Okay, so my understanding is Crown Counsel concedes that, but just not enough foundation has been laid. So if you want to just get Miss Blake to confirm that that was the case, I have no issue entering this. So I'll sustain the objection for now. Counsel, if you do want to get Miss Blake's to lay some more foundation about how she immediately took these notes, yeah, we can get it entered.
Yes, Your Honor.
Now, Miss Blake, when did you write down what you saw in your journal?
Well, I mean, right after shooing the people away from the car, I immediately dropped it down in my journal because, you know, my old brain doesn't work anymore and I might forget. So almost immediately.
And what did you write down in your journal exactly?
Well, exactly what I told you, that there were some loud noises in the Parker residence in the middle of the night. So
Objection, Your Honor. Just a point of order. We asked opposing counsel to enter the exhibit before talking about its contents.
I mean, it's up to opposing counsel as far as things goes. If they don't want to enter it, that's fine. They can just have the witness describe the contents of the notes if they would like. There's really no need to enter it.
Yes.
Unless you have another objection.
Not at this time, Your Honor.
Okay, yeah. You can continue, Miss Chen, or Miss Blake's.
And should I repeat my question again, Miss Blake?
Yeah, go ahead, counsel.
And what did you write in your journal?
well, exactly what I told you. There were some loud noises in the Parker residence, and I planned to tell him about it the next day.
And did you get to tell him?
Objection, Your Honor, as to hearsay. The statements referenced in the journals are out-of-court statements that are being used for the truth of the matter asserted.
Okay. Yeah. Any response to that, counsel?
Well, the journal entry made by the journal was the entry of like her like immediate what she saw and what she heard. She wrote it down and is her observations of what occurred on the March 14th, 2023.
Yeah, I don't see that as necessarily the point that counsel is making here. I think the point is more, is she using her notes from the entry in order to prove the truth of the matter in there? Is that the case?
Oh, I'm sorry, I didn't quite hear you. Could you repeat your question?
Yeah, I think what counsel is more referring is she using her entry in the journal to prove that the events of the journal actually happened?
Yeah.
Yeah, I mean, there's no exception that you want to use?
As to,
Is it hearsay, counsel?
but in the rule 8031, the present sense impression exception to the hearsay rule.
Yeah, okay. So at this point, I think it probably just makes sense for you to enter it. As far as things goes, I think there's been enough foundation laid that, like, okay, the witness wrote it immediately after. I think at this point, yeah, I would just get it entered. Like, this is kind of crossing into like this is kind of crossing into best evidence rule. I think at this point, if you want to keep, making reference to the journal, you need to get it entered.
Yeah.
So yeah, please do that, and then we can continue. All right.
So, Your Honor, the defense moves Exhibit 10A to C into evidence.
Okay. Any objections at this point?
None, Your Honor.
Okay. Yeah. So the exhibit has been entered. If you could just pull it up onto the screen, that way the jury can see. Yeah. Okay. Yeah. Mr. Shen, yeah, you can continue your questioning.
So, so what did you write in that journal exactly?
That there were some loud noises in the Parker residence in the middle of the night, and I actually planned to tell him about it the next day.
And after that, did you get to tell Mr. Parker?
Well, you see, before I could, I woke up to the sound of a truck engine roaring outside, and it nearly scared the biscuits out of me. I crawled out of the bed to the window so I could warn that boy Jordan, but he was already dashing off.
And do you know what time it was?
Well, it felt early in the morning to me, but ever since your old lady was told she had chronic insomnia, she just can't get the time straight.
Thank you. No further questions, Your Honor.
Okay. Thank you, counsel.
Your Honor, cross-examination?
Yeah, go ahead, counsel.
Yes, Your Honor. Your Honor, may I proceed?
Yeah, go ahead, counsel.
Yes, Your Honor. Good afternoon, Ms. Parker.
Good afternoon, darling.
Now, Ms. Parker, I want to begin with when the defendant came home. When the defendant came home, you observed her talking to some people, right?
Well, first of all, my name's Miss Flakes, thank you, but I did see him talking to some people.
And those people, you knew were involved with the gang?
Well, yes, of course. I mean, he talked to a bunch of people, and some I recognized to be part of that gang.
Exactly. Some people you recognize to be part of the gang, the Cobras, right?
Yeah, that's correct.
Man, that's a gang notorious for trouble in the area,
Yes, I would say so.
especially in drug trafficking.
Well, yeah.
And man, you thought this interaction was so interesting that you documented it in those journals that you showed us a moment ago, didn't you?
I did.
So you would recognize a picture of that journal if I showed it to you?
I would.
Let the record reflect that we're now going to be screen sharing what has already been entered into evidence as Exhibit 10B.
Okay, go ahead, counsel.
Thank you, Tech. So, on the Century, you wrote that they were dropped off, they referring to Miss Jordan Parker, by some kids who were sort of loud, they looked like Cobra members.
That's true.
So based on that, you had a clear view of Miss Parker's driveway.
I did.
Thanks, Tech, we can get the exhibit down. Now, ma'am, I want to talk about the morning that the defendant was caught concealing cocaine. You were woken up at 6:25 in the morning, correct?
Well, I mean, I really don't remember the time exactly, like I said, but I would say that it was really early in the morning.
Ma'am, is it your testimony today that you don't remember the time?
I do. I think I just remember that it was early in the morning.
Exactly, early in the morning at 6:25.
That's true. I would say so.
And you were woken by the sound of an engine.
Yeah, I rushed out the window and I saw Jordan Parker rushing off. Bless him.
All right, so stating for the record that now we'll be screen sharing a timeline. Or Tech, if we can get that up. Thank you. And you realize that engine was the sound of Miss Jordan Parker leaving town at 6:25 in the morning?
Yeah, like I said.
All right, and so early in the morning, you tried to yell that truck down.
I did, yes.
But Mr. Parker was too far gone.
No, he rushed off and I really couldn't tell him anything.
Exactly. That truck was too far gone, and you didn't see that truck come back, did you?
I mean, I don't go out spying on folks, but I never saw him come back.
So you never saw it come back. And so if someone got on stand today and said the defendant left at 10, they'd be lying, right?
I think so. I'm not sure.
Because you saw them leave at 6:25.
I did.
Let the record reflect that we'll be adding the date March 29th, 2025 to that timeline with the timeline 10:35 a.m. She tells us that the defendant, or rather someone else, would be lying if they claimed the defendant left at a different time other than 6:25. Now, ma'am, you didn't go knock on that door to make sure Mr. Parker wasn't home, did you?
I didn't. I mean, we're just
Oh.
neighbors. I don't stick my nose in other people's businesses, but I did not.
All right, because you were sure that that was Mr. Parker leaving town.
Well, I mean, I'm never sure, but I would say so.
All right, thanks, Tech. We can get the yes, great. Demo's already down. So you didn't try to contact Mr. Parker, did you?
I don't think so. Because, I don't have his phone number. His parents are out of town. I really can't.
Exactly. You don't have his phone number. And man, you just mentioned that his parents were out of town. Are you aware of the fact that Mr. Parker was in town to visit family?
Well, yeah, probably. But, I mean, he could just be visiting some cousins, but I'm never sure.
All right, ma'am. So I'd like to move to your relationship with Miss Parker. You like Mr. Parker, don't you?
Well, he's always a nice kid. I adore that boy.
Exactly. He is always a nice kid, so you're testifying in court for a person you like.
Well, I mean, I like everyone. I've seen so many things and I know everyone. I'm in love with everyone. That's just kind of me.
Ma'am, that's a yes to my question that you're testifying for Mr. Parker, a person you like.
Well, that's not why I'm testifying, but yeah.
And your testimony would help Mr. Parker get out of jail.
Well, I'm not sure. That'll be a decision upon the jury.
Ma'am, I'm just looking for a yes or no. Your testimony can help Mr. Parker get out of jail.
Well, I'm testifying the truth, but not because I like him, but I don't know.
So that's a yes to my question, ma'am?
I really don't know.
No further questions, Your Honor.
Thank you, counsel. Okay, counsel for the defense. Please call your final witness. Ms. Blakes, you can be excused.
The defense calls Jordan Parker to the stand.
Okay, Mr. Parker, yep.
Right. Can you introduce yourself to the members of the jury?
Good afternoon. The name's Jordan Parker.
And what do you do for a living, Mr. Parker?
I'm a delivery driver in New Dominicana.
Let's start from the beginning. March 9th. What happened that day?
Well, I was driving to visit some old family in Old Dominicana, but early in the trip, my truck broke down. It was a reliable truck. My uncle gave it to me. Been giving me problems for a few months, though.
And what did you do about it breaking down?
Well, I needed a new truck to continue my drive, so I went to the nearest rental and I rented a truck, a Dodge D150. It was okay condition for a rental. It got me to my family in Old Dominicana, at least.
Why'd you pick that truck in particular?
Well, I needed any truck that I could get for the drive, so I needed whatever they'd give me fast, because I had to make my way back to my family. They rolled out the truck. It looks okay, named a decent price. What choice did I have?
Can you describe the neighborhood of your family?
Old Dominicana. It's dangerous. Gunshots in the night, shady figures running around. A gang called the Cobras stalk that place. Crime is in all directions. I've always tried my very hardest to stay far away from the Cobras.
And what did you do during your time there at Old Dominicana?
Mostly meetings with family, old friends. It was a pretty nice time, besides, the gunshots in the night.
When did you leave?
March 15th. I think I left around 10 a.m., maybe sooner. I would have left sooner, but there was a lot of heartfelt goodbyes with family and old friends. On my drive back, though, I did get pulled over.
And what happened when you were pulled over?
The officer said some stuff, tinted windows or some baloney. I tried to explain to him that I was renting, but he wouldn't listen, and I got fined. Then the dog started barking at something, and I got arrested.
What was the dog barking at?
Apparently, a package of cocaine. Half a kilo. I never got into that kind of stuff, but you don't live in Old Dominicana without picking up a thing or two.
Did you know what he'd found at the time?
Well, at the time, I didn't know what was happening, but the drug dog barking, he was rummaging through the truck, and I left it totally exposed on the driveway in Cobra territory. I had a bad feeling. I was surprised and confused, and I got pretty anxious.
And did you know that the package was there beforehand?
No. Like I said, I wouldn't do that. It's a recipe for trouble. I got a stable job and a family. Why would I ever risk that?
What about the Cobra symbol on your car?
No idea how it got there. I could swear it wasn't there when I rented it. But then again, I left it out wide in the open in Cobra territory for basically anyone to see.
And do you have any connections with the Cobras?
Nope. I do not mess with the gangs. I sometimes speak to individual members, but I'd be damned before I even start thinking about working with those guys. Gives me chills just thinking about it.
All right, thank you for your time. No further questions, Your Honor.
Thank you, counsel. Cross-examination?
Yes, Your Honor. Good afternoon, Mr. Parker.
Good afternoon.
I want to pick up where you left off and talk about the connections with the gangs. You do have some connections with the Cobras, don't you?
No, I don't.
You said you stay far away from their life, but you heard Miss Blake testify. They saw you multiple times talking to Cobra members.
Well, yes. Again, I said I talked to individual members, but I've never talked with or interacted with the gang as a whole. I don't mess with the Cobras, all right? If you grew up in Old Dominicana, you'd know that those guys are nothing but trouble.
That's not true, is it? You
What?
admitted in an interview you were meeting with Cobra members, right?
Yeah, members, but not the gang. I don't talk with them because they're Cobra members, but because they're old friends.
Sir, you said you talked to the members, but not the gang. You know they're members of the gang, right?
Yeah, but I talk to them not about the gang, about like other stuff. I don't
Okay,
talk
Mr.
with them.
Parker. Well, let's just state out what we agree on. We agree that before you were arrested, you were talking multiple times with a few Cobra members, right?
Yes, members of the Cobra gang, but not the gang itself.
Sure. I want to talk about what you and Deputy Rodriguez agreed happened during the arrest. You agreed that after getting pulled over, Deputy Rodriguez found cocaine near the back of your car.
Yes, he did.
Deputy Rodriguez handcuffed you at the front of your vehicle?
Yeah, around the front.
And then before even seeing the cocaine in the back, you shouted out, "I don't know how that got there. Yes or no?"
Well, it doesn't take a stupid person it doesn't take a genius to know what was happening. The drug dog was barking, he was rummaging through my truck, and I left it in Cobra territory. I made an educated guess. I was scared. I was anxious.
You made a guess that there was cocaine in the back of your car.
Well, yes.
And that turned out to be an accurate guess, right?
Yeah.
Let's move on to your criminal record. In June of 2021, you're arrested with cocaine during a traffic stop, right?
Objection, Your Honor.
Okay. Other
As to
grounds?
character evidence.
Yeah. Yeah. You got an explanation there, counsel, for why you're bringing this up?
Yes, Your Honor. First, the defense has opened the door by bringing up character evidence of the defendant being a nice person. According to the same rule, the prosecution should get the same ability. Second, there is an exception for this specifically. Under 404(b)(2), falls under a common scheme or plan. Even if it's not explicit, it's certainly not for propensity purposes.
I mean, firstly, defense attempted to introduce positive character evidence, but I shut it down on the basis that they didn't give the Crown adequate notice. Secondly, even if they were to introduce positive character evidence on direct examination, you would have to challenge that evidence on cross-examination of the witness, which is gone already, right? Like, you can't bring this up during Mr. Parker's cross now.
Sure, Your Honor, but
yeah, with regards to your second point, you were saying that this falls under a common plan or scheme.
That's right.
Okay, Mr. Hong, any response to that?
Yeah, of course, Your Honor. So the specific wording is the evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistakes, or look of accident. This does not do any of that, and it is merely here to show my client as a bad person that he's done it once, he'd do it again.
Repeat the exact list of exceptions again.
Of course, the exact list of exceptions are admissible for another proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistakes, or lack of accident.
Yeah, so I mean, counsel used common scheme, but we can call it plan, right?
Yes.
What's your response to that? That this is part of an ongoing plan to traffic drugs?
Your Honor, these are two completely unrelated events, and it does not show any sort of planning. The charge against Mr. Parker does not show any sort of planning or motive, especially as the case was deemed not guilty, was dropped based on lack of evidence, and so this cannot be used against him. It is merely to show that he has been suspected once of trafficking cocaine and that he'd do it again because of that.
Yeah, any response to that? Mr.
Yes, Your Honor. Regarding the exception specifically, we think that this not only falls under a plan, but also an absence of mistake and a lack of accident. There's no mistake or accident because the facts of the case are nearly identical. They're caught with almost 1,000 doses of cocaine, but that was connected to the same gang, the Cobras, and they were caught. Even if the case is dropped, we have a reasonable expectation that the defendant will admit there was cocaine in the car and that it was from someone else, the Cobras. We think that is similar enough to justify entering.
Yeah, I mean, this is a tough one. I'll hear one more response from the defense before I make my ruling.
Of course, Your Honor. So this does not show any sort of plan. This is not here to demonstrate motive. This is not here to demonstrate why Mr. Parker would have done anything. This does not show how he would have done anything. Just because the cocaine is allegedly sourced from the Cobras in both scenarios does not make it likely that he would do it again. And the whole purpose of bringing up this case is to make my client look like a bad person, which is character evidence.
Yeah, I mean, like, the absence of a mistake, I'm not sure if I buy that. To me, it doesn't seem like it's the sort of thing where, yeah, like I don't really quite buy the whole absence of mistake thing. So yeah, I'm gonna sustain the objection. I don't think this should be allowed. just the prejudicial value of this, especially given the fact that it resulted in no conviction, is frankly speaking too high for me to be comfortable with it, even if I were to accept that this falls under one of the character evidence exceptions. So yeah, objection sustained. Please move
Yes,
on
Your
to
Honor.
the next line of questioning.
Yes, Your Honor. Mr. Parker, let's now talk about what happened on the morning of the day you were arrested. You came back late around 1 a.m. that day, right?
Yep, I did.
Stating for the record, the Crown is screen sharing a demonstrative. You've been sitting through this entire trial, haven't you?
Yes, I have.
You heard Miss Blake testify about what happened on the morning of March 15th?
Mm-hmm.
The same day you're arrested by Deputy Rodriguez?
Yes, it was the same day.
You heard them say they saw you leave your house at around 6:25 a.m.
Was it 25? Around 6, yeah.
Co-counsel, if we can go back to the previous slide. This is what we heard Miss Blake testify to, right?
Yes, I believe so.
6:25 a.m., the defendant left their residence, right?
Well, not that I left, but that she heard a car.
She said you left, right?
I believe so, yes.
She said at 6:25 a.m., quote, I saw Jordan Parker rushing off, right?
Yes, I believe so.
But your story's different, is it?
Slightly.
Objection hearsay.
Yeah. Explain, counsel. How's this hearsay?
I do believe that they are bringing in parts of Miss Blake's affidavit, which have not been stated in court here today. So unless they can provide an in-court statement, this is an out-of-court statement being brought into court.
My recollection of the last question was your story's different. How's that hearsay?
I believe if you could re-ask your last question, the question before your last question, like the last two questions.
Your Honor, may I do so?
Yeah, go ahead, counsel.
You heard Miss Blake testify, I saw Jordan Parker rushing off at 6:25 a.m.
My apologies, Your Honor. I thought he brought in quotes from Miss Blake's affidavit and not in court statements.
Okay, yeah. So objection withdrawn. Yeah, continue your questioning, counsel.
Yes, Your Honor. You say you woke up late.
I think I woke up late. Again, I went to sleep really late last night, so everything's kind of fuzzy from that morning.
Sir, you say you woke up at 10 a.m.
I think I did. Could have been earlier. Again, everything in my mind was super fuzzy and I can't really remember.
Sir, previously you've testified that you left at 10 a.m., right?
Yes.
So at 10 a.m. you left the residence. Previously on cross-examination, we heard Leslie Blake testify that if another witness said you left not at 6:25 a.m., they'd be lying, right?
Again, I think so, but
you've been sitting through this entire trial, haven't you, right?
Yes, I have.
So you are sure, because we just heard Leslie Blake testify that if any other witness claimed a different time than 6:25 a.m., they would be lying.
Well, that's what she said, yes.
And you're saying that it was not at 6:25 a.m., right?
Well, Leslie Blake is old, and I was so tired. I think I might have misremembered it, but yeah.
Sir, you might have misremembered it?
Yes, maybe. I can't, again, I went to bed really late, and my memory is all fuzzy. I think it was around 10, but it might have been earlier, might have been later. I'm not sure.
It's your sworn testimony that you are not sure when you woke up that day.
No. I might have misremembered, but I think that it was 10.
You're certain it's 10?
I wouldn't say certain.
Do you remember writing an affidavit before testifying?
Yes, I do.
You were told to write the entire truth and nothing but the truth.
Objection. Improper impeachment.
Okay, explain, counsel.
I do believe that the opposing counsel has not laid enough foundation to impeach my witness.
Yeah, overruled. Go ahead, counsel.
I'll re-ask my question, Mr. Parker. You remember writing an affidavit and you were told to write everything that was truthful, right?
Yes, everything that I thought was truthful.
You knew that if anything new happened to you, you could update it at any time.
Yes.
This looks like a fair and accurate copy of that affidavit, right?
Let me see. Yep, looks good to me.
Scrolling to the bottom, that's your signature, right?
Yes, it is.
Now I want to redirect your attention to line 37. I'll read out loud while you read silently. It says, on March 15th, I woke up a little bit late, leaving my house at around 10 a.m. In my defense, I had a lot of goodbyes to say and hugs to give. Did I read that correctly?
Yes.
And Mr. Parker, nowhere in this sentence or the following sentences does it say, I wasn't sure, my memory was fuzzy, I might have been 10 a.m. There was no uncertainty in this, right?
Well, I thought at the time, I thought it was at around 10 a.m., but I left my house at around 10 a.m. I woke up at a different time. Again, it says around. I'm not exactly sure if it was 10 a.m. It was just around 10 a.m.
Sure. So you testify and we agree. You left your house at around 10 a.m. Correct?
Around 10 a.m.
That is a 3.5 hour disparity from what Leslie Blake just testified to.
Yes, it is.
So you would say if anyone else said you left not at 10 a.m., they'd be lying.
I wouldn't say that, especially because Leslie Blake is old and I know she has insomnia issues, so maybe she misremembered.
Nothing further, Your Honor.
Okay, thank you, counsel. Okay, yeah, I think that wraps it up. Nice job, guys. So let's have another quick break, give the closing attorneys an opportunity to prepare their speeches and compile their arguments. We'll regroup at 2:20. Okay. And then we'll be moving into closing arguments. So yeah, 2:20, we'll resume.
Okay, you did good.
Okay, I think we're good to get back into it.
Yes, Your Honor, the Crown is ready to proceed.
Yeah, excellent. And counsel for the defense, are we
The
ready?
defense is also ready to proceed, Your Honor.
Excellent, excellent, excellent. Okay, let's jump in. So closing arguments, counsel for the Crown.
Yes, Your Honor.
One final thing before we start moving. Just want to quickly confirm with my fellow justice that she's good to go on the scoring side. Yes. Okay. Fantastic, Justice Young. All right, Mr. Kuo, begin when you're ready.
Yes, Your Honor. Imagine this. You're playing a game of Monopoly with a friend. In the middle of the game, you catch them sneaking extra bills from the bank. You tell them it's just a game, and they insist they won't do it again. And they don't. Not for a couple rounds at least. But just when they are about to go bankrupt, when they thought they could get away with it, you turn and you see them sneakily taking another $500 under the table. He got caught once, promised to never do it again, but when push came to shove, they did it again. The Monopoly cheater, that's the defendant. He made a promise, got caught, swore they were done, but when money was tight, he reached right back into the bank. In this case, however, the defendant wasn't concealing cash. He concealed for cash. But members of the jury, Jordan Parker never got that cash. That's because their agreement was that they would smuggle the drugs back to New Dominicana, but only then would the Cobras pay him. The reason why Jordan Parker's plot got foiled? Officer Tom Rodriguez. During her usual patrol, she noticed a car's tinted windows. One thing led to another, and Officer Rodriguez uncovered the scheme, finding what later weighed in at 470 grams of cocaine. But the fact that there was cocaine isn't important to this trial, because the defendant admits, and the defense agrees, that there was in fact cocaine. They don't dispute any of that. Given that we, the Crown, have charged Jordan Parker with possession of a controlled drug for the purpose of trafficking, we have to prove that beyond a reasonable doubt, and we did. A reasonable doubt has to be based on reason and common sense. If the defense provides you with imaginary or frivolous doubts, that is not reasonable. The defense might try to tell you that this was a misunderstanding, that Parker was just in the wrong place at the wrong time. But that's not how drug smuggling works. That's not how crime works. And that's not how reasonable doubt works. The defense has tried telling you that the defendant was caught without a clue. But that could not be further from the truth. They knew exactly what was in the back of their truck because they placed it there. The defendant did pretend like they didn't have a clue, though. They didn't mention any suspicions during the arrest, during an interview, or any affidavit. That's because there weren't any alternate suspects. The defense has tried to tell you we have no other piece of evidence besides those symbols, but that's just not true. The defense's own witness, the defendant's neighbor, testified about how they saw the defendant talking to Cobra members multiple times. In fact, it's in writing. We showed you the journal entry where Leslie Blake says the defendant was meeting with Cobra members multiple times. You'll be able to take that back to the deliberation room, and you'll realize that what Leslie Blake says in this journal is true in its entirety. The defendant was meeting with Cobra members very early and very late. They used their connections at the Cobra gang to get money fast. Throughout this entire trial, the defense has never once clearly explained what they mean. They haven't said if it means that a deputy placed the cocaine, or that means they lied about the incident, or whether they are saying the entire interaction was made up. Now today, we've met our burden by walking you through the real story of what happened on March 15th, and proving that through the two facts, concealment and the cash. First is the concealment. You heard Tom Rodriguez come up to the stand and testify about the arrest. They testified not only about the cocaine found, but the defendant's incriminating reaction to the package. When Officer Rodriguez had handcuffed the defendant, they'd stayed at the front of the truck. When Officer Rodriguez discovered the mysterious package, it was still in the trunk. You heard from Officer Rodriguez that there was no way that the defendant, handcuffed at the front of the car, could have seen the package in the back. Yet she still said, it's not what it looks like. It's not what looks like. Members of the jury, Remember, at this point, the defendant doesn't even know that the officer had discovered anything. The package was in the trunk, and Officer Rodriguez hadn't said anything, didn't ask anything, didn't even react to the package. Every fact from the arrest points to the fact the defendant knew about the package. The only question is why the defendant had the package. Sergeant Jameson Grant's job was to answer that question. Sergeant Grant is an expert narcotics officer, but a lot of her conclusions were obvious ones. She noticed symbols on the package in the car that anyone can identify as COBRA symbols. She pointed to the fact that the defendant was financially in need, including that it made it more likely to be a drug. Our second fact is the cash. In the defendant's own words, times have been hard. After they lost their job, they were in need of money and saw a perfect opportunity to cash it. The only people without a clue today were the defense witnesses. You heard on stand the neighbors say the defendant left early in the morning. But on the other hand, the defendant told you that he didn't leave his house until 10 a.m. Quite frankly, members of the jury have a pretty easy job prosecuting the defendant today because somehow both of their defense witnesses called each other liars. You heard it, and now you see it on the screen. You gotta ask yourself, is it reasonable to trust a defense whose theory is built on the back of liars? Or is there a reasonable possibility that when all the clues, all the puzzle pieces put together shows you a clear picture? The defendant had a clue. She knew she trafficked drugs because she concealed for cash. Now, the defense will get up and tell you the only evidence we have of a connection to the Cobras is from Tom Rodriguez, and they'll be wrong. Leslie Blake's testimony of the defendant talking with Cobras is evidence. Leslie Blake's journal proving that is evidence. The defendant's own words in the interview with Tom Rodriguez admitting they were talking to Cobras is evidence. The defense will wave their hands, ignore the pieces of evidence, but you can't. Everyone in this courtroom has agreed the defendant was talking multiple times with Cobra members. Members of the jury, if you meet with members of the Cobras, you're meeting with Cobra members. Everyone in this courtroom agreed there was cocaine in the truck. Everyone agreed there were Cobra symbols on the cocaine in the truck. What more does it take to prove that there is not a single other reasonable explanation? 470 grams of cocaine. Heard from Sergeant Jameson Grant that that's enough to last 25 years, enough to destroy lives, to fuel addiction, to bring crime into our streets. And Jordan Parker was willing to bring that back for a payday. The law is clear. The evidence is clear, and the verdict should be just as clear. Jordan Parker is guilty. Thank you.
Your Honor, permission to proceed?
Yeah, give me one moment here. Okay, go ahead, counsel, whenever you're ready.
May it please the court, he was caught without a clue. Your Honor and members of the jury today, throughout the trial, the Crown has told you a story of guilt, of desperation, of pressure. They told you that he concealed for cash, but that's simply not true. The truth is, he was concealed from the truth, and now he is being concealed from justice. My client's story is a series of unfortunate events happening at the same time, starting from the COVID pandemic and lasting all the way until now. He didn't need the trouble of risking everything, his job, his family, maybe even his life. For what? A quick buck? But the Crown doesn't see that. Instead, they charged him with possession for the truth of trafficking. But the truth is, he was caught without a clue. Now, today they had to prove to you that Mr. Parker was trafficking cocaine in that rented truck. And they have to prove it beyond a reasonable doubt. And I'd like to remind you today that that burden does not fall on us. It falls on the Crown. They bear the burden of guilty beyond a reasonable doubt, the highest one in our legal system. Because it means that their way must be the only possible way things could have happened, the only reasonable way things could have happened. That means you can't just find their story probable. You can't just find it likely. You must believe that there is no other reasonable explanation for what happened today. And they have failed to meet that burden. But what about us, the defense? We didn't have to do anything. We could have just sat here and asked questions, provided just one reasonable doubt, just one reasonable alternative, we win. And today we didn't have just one reasonable doubt, we had thousands of them. But I'll present to you today 2 points, the vehicle and the investigation. First, the vehicle. You heard from both Jordan Parker and his neighbor that he was driving a rental truck, a Dord D150. It was not his personal vehicle. It had been used by many people before him. He had absolutely no control at all over the modifications on the truck, or anything on that truck in general. Not only that, but the drugs in question were found hidden in the spare tire, which makes it hard for cops to find, yes, but also for unsuspecting renters to find as well. Members of the jury, the Crown has been roasting my client for not thoroughly checking his rental truck. But let's be real. How many of us here, when we're in a rush, when we're tired, when we're busy, would take the time to inspect a rental car? We don't know how long these drugs were there for. We don't know who put them there. Those drugs could have been hiding there for months. They could have been placed there during his visit. They could have been placed there 101 times when my client was vulnerable, when he was away from the truck, when he was turned away, leaving Mr. Parker caught without a clue. This brings me to my second point, the investigation. Now, there was no proof that my client knowingly obtained the drugs. And the only reason the officer suspected Mr. Parker knew anything was a suspicious reaction when she found the cocaine. A suspicious reaction we have only her word to rely on because, well, she didn't bother turning her body cam on. Well, let me remind you today, suspicious isn't a crime, and it sure isn't definitive proof of anything. The only other thing they have to go off of is some psychological profiling and other circumstantial, superficial pieces of evidence. They have nothing. Sergeant Grant's mentions of the I-102, that it's a popular drug highway, circumstantial. The truck modification has nothing to do with the witness. He had no control over it. Character evidence of gang affiliation and a trial dropped for lack of evidence? Well, character evidence, and frankly irrelevant. They have no fingerprints, no DNA, no written records of communications with the Cobras, nothing to tie, without a reasonable doubt, the drugs to my clients. The only solid piece of evidence they have is inconsistencies on when my client left, which A, doesn't prove anything, and B, my client was tired, and Miss Blake is old. Memory fails, the edges turn gray, but the core truths are before you. Now, Sergeant Grant's conclusion, their expert witness, was based entirely off of the things I just mentioned. Character evidence, psychology, something she doesn't have a degree in, and a few other circumstantial, superficial pieces of evidence. Now, is this enough to send a man to jail? To ruin the rest of his life? At the end of the day, we don't have the last say. The Crown doesn't have the last say. You have the last say. The evidence we show you today, that doubt isn't just present, it's everywhere. The Crown has done nothing but manipulate false into fact. They have no numbers, they have no photographs, they have no written records, nothing. As you listen, consider this. likely isn't enough. Suspicious isn't a crime. And in our justice system, doubt means you must rule innocent. We ask you to find Jordan Parker guilty because he was caught without a clue. Thank you.
Okay, thank you, counsel. All right. Whew. All right. That's it.
Your Honor, I believe the Crown still has a rebuttal.
Oh, yeah, that's right. Yeah. How much time does the Crown still have remaining?
3 minutes and 1 second.
Okay. Yeah, my apologies. Yeah. Counsel for the Crown, go right ahead.
Yes, Your Honor. He concealed for cash. The defense witnesses are the ones that have no clue. Ask yourself, why on earth did they come out of their way to testify? Like the defendant admits, they weren't sure. Leslie Blake said multiple times in their cross-examination, and I quote, "I'm not sure about anything." Mr. Hung is right. The defense could have just sat here and done nothing. And I'll be perfectly honest with you, members of the jury, it probably would have been better for the defendant if nobody testified. They would have been more likely to have gotten out if they didn't even talk. Sounds like an exaggeration, but not when you remembered what happened in this trial. I didn't roast the defendant for not inspecting his truck. I'm roasting the defendant for not having a clue about anything in this case. We showed you a demonstrative that both defense witnesses testified to. You heard Leslie Blake say that the defendant got up, left their house at 6 a.m. You heard her say if anyone were to stand up and testify, the defendant left any time after 6 a.m., they'd be lying. And guess what? A couple minutes later, the defendant themselves got up and said they left at 10 a.m. The defendant themselves told you not to trust the account of Leslie Blake. Quote, "She's an old woman with insomnia and could have misremembered." Another quote, "My client is tired and Miss Blake is old." That's what Mr. Hong just told you. They seem super sure of themselves in the affidavits. So why are they suddenly so unsure? Miss Blake didn't age 15 years since writing that affidavit. So when you go back to your deliberation room, do not forget what the defendant said. He lied on stand today. He said he wasn't sure what time he left his house that day. Why? Because he didn't want to seem like a liar. But in the end, they lied on stand. They forgot they had written an affidavit where it says in plain text, "I woke up late, leaving my house at around 10 a.m. No uncertainty, no maybes." So what caused them to forget? Possibility of multiple years in jail. Now, what Mr. Hong forgot to tell you was that circumstantial evidence is still evidence, and it's evidence that can be enough to convict the defendant. Don't just take my word for it. When you go back to the deliberation room, members of the jury, the law will tell you circumstantial evidence is enough. Today, we showed you plenty of evidence. The truck, the package, the debt. All things that pointed to the defendant concealing cash. You heard from the defendant and the other witness themselves. They aren't sure of their testimony. Find him guilty. Thank you.
Thank you, counsel. Okay, awesome. Well, great job, everyone. I'm officially sort of taking off my judge's cap now. Yeah, it's nice. I feel like, there's always a sort of, what do you call it? Sternness that, I sort of need to put on whenever I'm judging these things. But once it's over, yeah, all the pretenses are gone. You guys are now no longer opposing counsel. You guys are friends again. And yeah, we've come to the very end of the trial. So at this stage, Justice Young and I will be popping into a separate breakout room. So she's the one who's been responsible for the scoring today. So we're going to convene quickly, and then shortly after, we'll be returning back into the main room in order to deliver the results and to share some feedback. Just wanted to say beforehand that I think everyone did a really, really solid job. Saw some really great stuff all around, and I'm really impressed with the level of advocacy that was demonstrated here today. Definitely a round that's worthy of being the finals. So, Yohan, do you mind setting up a separate breakout room so that we can head off and convene, and then we'll resume shortly after. All right?
Of course. Yeah, the room should be open.
Okay. There we are.
Nice job, everyone.
Yeah, great trial, guys.
Thank you so much. You guys did really good.
So we saw in the finals. So I say we're going up against Christiana's team. I'm like, oh, we're cooked. Like, we're so cooked. It's like, okay, so like, if Christiana, like, she's doing POA for Crown, so I think we're fine, right? She's gonna like destroys once, and then we're fine. Okay, who else is on the team? So okay, Vivian's on the team. I'm like, oh, okay, we're so cooked. And then okay, who's anyone else? Okay, Anya